Hello everyone, I am Harshita Mewade, a second year law student from United World School of Law, Karnavati University, and currently I am interning under Sejpal Associates Advocates in Ahmedabad, Gujarat. Today I'll be discussing a landmark judgment of Honorable Supreme Court of India, that is Maneka Gandhi versus Union of India. This case is also known as the personal liberty case as it became one of the milestone cases in the history of Indian legal system. This landmark ruling was delivered on 25th January 1978 by pronouncement of a unanimous decision by 7-judge bench of the Apex Court. The petitioner in this particular case is a well-known environmentalist as well as an animal rights activist. Let us discuss the facts of the present case. Maneka Gandhi was a journalist who was about to travel abroad for some of her official work, for which she applied for the passport. On 1st June 1976, her passport was issued, but on 4th July 1977, she received a letter from the regional passport officer informing that her passport was impounded by the Government of India under the ground of interest of general public, to which Maneka Gandhi immediately wrote a letter to the regional passport officer demanding reason for such an order. On 6 July 1977, the External Affairs Ministry responded not to state the reason for impoundment, again under the pretext of the interest of general public. Aggrieved by this, the petitioner moved to the Honorable Supreme Court of India under Article 32 of the Constitution, contending that this act of passport authority infringes the fundamental rights guaranteed under the Constitution of India. Before discussing the issues of the case, let us first understand the relevant provisions of the Passport Act of 1967, under which the authorities had impounded the passport of the petitioner. The first provision is Section 10, Clause 3 of the said Act, which states that the passport authority may impound or cause to be impound or revoke a passport or a travel document. In other words, this section confers power to the passport authority to impound a passport or a travel document. Subclause C of the same section states the reason by which the passport authority can impound the passport. One of the reasons stated in subclause C is in the interest of general public. The same reason was given by the authorities to the petitioner in the present case. Another provision of the Act is Section 10, Clause 5, which states that Passport Authority shall record in writing a brief statement of reason for making such order of impoundment. In this particular case, the Passport Authority decided not to state the reason for impounding the passport of the petitioner. After going through the facts and the relevant provisions of the case, following issues were raised before the Honorable Supreme Court of India. The first issue was whether right to travel abroad is protected under Article 21 of the Constitution of India, which guarantees right to life and personal liberty. The second issue was, are the provisions under Article 14 that talks about right to equality, Article 19 which guarantees right of freedom of speech and expression and right to freedom of movement, and Article 21 are interconnected or are they mutually exclusive? Let us understand this with a simple example. Suppose my Article 21 is being violated. The question is whether such violation or infringement leads to violation of other rights guaranteed under Article 14 and 19 or not. The third issue before the court was, should the procedure established by law under the Passport Act of 1967 can be tested for reasonability. Meanwhile, the fourth issue was whether the impugned order of regional passport officer is in contravention of principles of natural justice. This immensely important judgment altered the landscape of Indian Constitution. It widened Article 21's scope and realized the goal of making India a welfare state. The first observation made by the Supreme Court was that right to travel abroad is a fundamental right guaranteed under Article 21 of the Constitution of India. The Supreme Court cited the judgment of Satwant Singh Sahani versus D. Ramaratnam, which was delivered on 10th April 1967, wherein the Supreme Court held that personal liberty in its ambit also includes the right of locomotion and the right to travel abroad. Regarding the second issue, the court held that Article 14, 19, and 21 of the Constitution are mutually connected with each other. In Maneka Gandhi versus Union of India, the landmark case of A.K. Gopalan versus Union of India was overruled, where the Supreme Court held that the provisions of Article 14, 19, and 21 are mutually exclusive. The Supreme Court in this case held that there is a unique relationship between the provision of Article 14, 19, and 21, and every law must pass the test of the said provisions. The view that Article 19 and 21 constitute a watertight compartment was rightly overruled in the case of Maneka Gandhi. The court stated that Article 14, 19, and 21 are interrelated and establish a rule called the Golden Triangle Rule or the Trinity Rule. The court further held in this case that the procedure established by law shall not be arbitrary and irrational. The phrase used in Article 21 is procedure established by law, and the court was of the opinion that the procedure shall be free from any arbitrariness and irrationality. According to Supreme Court in this present case, the provisions of the Passport Acts were arbitrary because the authorities did not give a valid reason for impounding the passport of Maneka Gandhi. The court further stated that the impugned order was in clear violation of principles of natural justice. The court was of the opinion that the petitioner's right to be heard, which is a fundamental principle of natural justice, was violated as the passport authority didn't give the petitioner an opportunity to be heard. The court further stated that ordinarily no passport could be reasonably impounded or revoked without giving prior opportunity to be heard to its holder. The Honorable Supreme Court at last directed the passport authorities to return the passport to the petitioner and quash the impugned order. So, this was all about the landmark ruling of Maneka Gandhi versus Union of India, which stands as a bulwark of the right of personal liberty guaranteed by Article 21 of the Constitution. Thank you for watching.